Well, hello there. This is Alan Jimenez, real estate broker at HPAgents.com. Been doing real estate and practicing real estate for the last 15 years. Today, we're going to be talking about wholesale real estate, and in particular, we're going to be talking about the sales contract. Now, the sales contract is a legal document. It binds you, the buyer, and the seller. It can be held up in court. So it's very, very serious that you take this very, very serious. So what we're going to be looking at today is a Texas Real Estate Commission contract. Now, I highly suggest you get your own contract written. You hire an attorney to write one for you. Maybe you write your own if you kind of are very good at legal documents, or just buy one of our templates. Easy to use. They've already been promulgated and created by a broker or an attorney here at HP Agents. So, and of course, do your own due diligence. Not just, go upon our word. Go do your own due diligence and do your own work and check your paperwork, because this is a very, very serious topic we're about to join in on. So let's get right into it, okay? We're going over this Texas Real Estate Commission. The first thing I like to let people know is that if you don't have a real estate license, and you really can't be using this form, but I've seen people use it before, not saying that you should or that you could or whatever, because I have a broker's license. I have to be very careful with my wording, so do your own due diligence. But if I've seen people use it before where they say, okay, well, I'll just take out this Texas Real Estate Commission. Sometimes they'll say only used by realtors. Take that out. Any kind of changes that you make like that, have the seller and you sign. Have the seller and yourself initial next to that change. So the things that you should have on this contract, of course, are who the parties involved, the buyer, the seller. Then you're going to say, okay, what property am I buying? And you need to have the legal description. And you can find that legal description if you go to the local city appraisal district. So for like Houston, it's just Harris County Appraisal District, usually Dallas County Appraisal District. Whatever your city is, blank city appraisal district, you'll find it. Go to the address, do the property search, and you're going to be looking for lot, block, and some other little subdivision information. Say it may look like lot 4, block 6 of Timber Grove area, section 2 or something like that. You want to put that in there. You want to have the city, the state, the county, and then you want to have the actual address right here, known as an address. And these are the improvements that go with it. You want to make sure that every improvement that you can go with it, so you don't have any kind of discrepancies. I've seen people take the above ground pool because it was one of those things that was excluded. It's not actually included in an improvement in this contract. But things that you want to be included, you need to include it in the improvements, okay? This is not a real estate writing contract class. This is a wholesale real estate license class, or a wholesale real estate class. So now the accessories, if you have any window air conditioning units, above ground pools, you see it right here, swimming pool equipment, all this stuff has to be. What are the exclusions? So let's say that a seller says, no, I want to keep my chandelier. I want to keep my doggy house in the back. Let's not have any problems with this transaction. Put it here. We're not trying to cheat people. We want to go clear, black, and white. He doesn't want this, and guess what? This doesn't go with that property, okay? Reservations or oil and gas, I don't see that very much, but you can put that in there. Sales price, this is where the sales price, if you're going to be doing wholesale real estate, most of the time you're going to be using cash. So cash portion will be $250,000 cash. But I know I hear you guys already saying I don't have cash, but it's okay. We're going to be using a hard money loan or a medium money loan, or we'll even put in a disclaimer later on saying that we can change to financing. We'll get there. Hold on, okay? License holder disclosure. If you do hold a license, or anybody of your LLC entity, a partner has a license, disclaim it. You don't want to have any problems with your real estate commission. So all you have to do is disclaim that you have a license, and you put your license number there. Easy as that. Now, the earnest money, of course, is going to be like almost like a deposit that a title company will hold. The title company doesn't care about the buyer or seller. All they care about is the new buyer gets the title of this property free and clear of encumbrances and liens and taxes and mortgage, all this kind of stuff. When the new owner gets it, it's free and clear. And if they have a problem, then they can give them the insurance for the title. Say somebody knocks on the door, hey, nobody paid me for this roof. No problem. call Fidelity National Title. This is how it goes, okay? You put your, let's get back. What I like to use Fidelity National Title, but you're going to associate yourself and create a relationship with the title company because they're going to be doing a lot of homework for you. So you just want to stick with one or two of them that are good and then keep giving them business because you got to have that relationship, okay? Liens and properties and exemptions, all this stuff is pretty standard. Basically means that, we want to get that, the blot and block, the legal description, we want to own all that property, okay? If there's a shortage in the area, you want the seller to pay for it, but, it's negotiable. Like, let's say, for instance, 5,000 square feet lot, but it comes in at 4,900. Then we're missing 100 square feet, then the seller will pay for that shortage and some kind of negotiation. The commitment, title commitment means a title company is going to give you a commitment after the within 20 days, you'll get the commitment saying all the schedule A, B, and C, things that they found with the title. They're going to be like, hey, we found out that 20 years ago he had a son and it's on the schedule B and we're going to have to clear it. So it gives you time to, when you get the title commitment, to review it and to either object and back out, or if it's not a big deal and 99% it's not a big deal, and then you just keep moving forward. But we'll talk about that later because it could be a loophole that you use to get outside of the contract. The survey, survey within 5 days, I usually like to put 5 days. Seller shall furnish the buyer a new survey, or they will be paying for the survey. They're responsible for the survey. That's what we like to put. But of course, it's a negotiation. It's not set in stone. So whatever you got to do to get this property, if you're making $50,000, $20,000, $10,000, don't worry about the survey too much. But it does offer a loophole if they didn't provide it to you, and we'll talk about loopholes in a minute. Objections. It means that when you get that title commitment, we're still on title. Remember, this is A, B, and C. Let me try to get this. We're still on title, policy, and survey of Section 6. So A, B, and C of 6. And we're going to be going here. So if you have an objection here, and then let's say, for instance, hey, there is an exception or an incumbents to the title. That means there's something happening with the land that maybe the neighbor is adjoining, the city has a little part of it. Nobody disclosed it to me. It's the first you ever found out about it. So now you have to object. And if you object, you get your earnest money back. Of course, you lose your option fee, but that's not a big deal. This is a part of due diligence. Well, what else we're going to go through here? Title notices, abstract title. This is all standard stuff. You can read through it if you want. I'm going to just give you, I don't want to mix you up a lot of things. Okay, property condition. We're going to move over to 7 because 6 was all title commitment. Buyer has not received the notice. Seller's disclosure notice. A seller's disclosure notice is another form we're going to be talking about. You need to have the seller just fill it out. And basically what it is, it tells you every single thing that's wrong with the property. Have it ready. If you're going to be wholesaling the property, you're going to be want to have this document handy so you can give it to the next buyer. So he's aware of all the problems. You want to have all your ducks in a row. And if he likes the property, he'll move forward. If he doesn't, then he doesn't waste any time. So, and you want to have this seller disclosure. It's a legal document. So if they know there's a crack in the foundation, they had problems They had problems with the foundation, they had repairs, and they didn't disclose it, the seller can get sued, and it just offers you a way out of the contract, and it's just more advantageous for you because you can get out of the contract and get your earnest money back. Remember, you got $1,000 on the line, $5,000, $10,000, $20,000 on the line. Depends. If you get a $2 or $3 million property, yeah, they're going to want 1%, $20,000. Okay, so you want to say buyer has not received the notice, and within 3 days of the effective date of this contract, seller shall deliver the notice. So you hand him over that form to fill out, but he has so many days to get it back to you. But you don't want to nag him about it because if he forgets, sometimes it offers you another loophole to exit out of the contract. So the name of the game is kind of, let's say, for instance, you have a buyer within 1 day. One day you already know you're going to resell that property, then yeah, you need that seller's disclosure. But if you are trying to wholesale that deal and it's day 5, 6, and you don't have that seller's disclosure, don't go nagging on him just yet. The reason why is because you want to have a loophole out of that contract. You want to be able to get your earnest money back, and this offers that loophole. Because as you can see, the seller was supposed to provide it for you in 3 days. And if he didn't provide it to you in 3 days, then it gives you a loophole to back out. You get it? You see where we're going with this? Yeah. So I really would suggest that you use our template because it's written advantageous for the buyer, you. This, like a Texas or a state contract, is written to be fair to the buyer and to the seller. And so, if you're protecting you just like a lawyer would, I know it sounds a little bit odd, but a lawyer, and we get contracts all the time written by lawyers, is that they write them advantageous for the buyer. Who's the buyer? Their client. And in this situation, we already have one already written. Just buy the template and get it and use it. Just fill in the blanks. It's so easy. Keeps you out of trouble. And of course, do your own due diligence. You accept the property as is only if you didn't negotiate like some kind of repairs beforehand. So if you got the property and you say, hey, I need you to fix that wall and the hole in the wall, then of course you put that here. And it does not mean that he will not do repairs. It's just at the time of signing that you accept the property as is. We have the option period we'll talk about in some, we'll get to it shortly. And that's when during this period we'll do our negotiations on repairs and or a budget or both. Lender required repairs means that sometimes lenders will require a repair. And that's what this area is about. Completion of repairs must be satisfactory. When is the closing? You don't want to put a closing date as standard because you want to say you're going to be sending out this form a lot. So you don't want to be calculating. Just put 15 days after execution. And I know you're thinking that's short. Where am I going to get the $250,000, $500,000? I don't have it. But hard money lenders, medium money lenders, and investors, if it's a great deal, they will get it done, and we'll move forward. And we'll talk about that soon in financing. Possession means that you're going to get it upon closing and funding. That means when you close on that property and you fund it, the bank funds it, you get the keys. You don't get to move in early. Don't even try to move in early or some kind of crap like that. There is no leases, and sometimes you can do sometimes there will be a lease to seller that you can negotiate. Sometimes the seller says, hey, I need more time to move out. And this is where it would go, and we're going to talk about that in attached forms. Okay, special provisions. Special provisions are where you want to just put hardcore facts. I mean, there's no if, ands, or buts. I have a real estate license, so I like to say one more time that I'm a real estate broker. Here's my license number. I also put the fact that buyer may use financing or a line of credit to fund this transaction. It will not change the net proceeds to seller. You see that? Because here's my disclaimer is that, hey, I might use financing. He has the right to use financing because I don't want to change the financing and then the seller want to be like or wants to use that change in order to back out of the contract because now you changed the terms and you said, oh, you're going to pay cash. You were going to pay cash for this, Alan. Well, if you're going to change for financing, that's not a part of the deal. You're supposed to be $255,000 cash. Wait a minute. Look at Section 11. You signed off on this contract that says that I can use financing and or a line of credit. There it is. Done. So always CYA, cover your ass. CYA, cover your ass. Section 12, closing costs. In the template, it will be labeled closing costs. And this basically means seller will be paying X amount of dollars to you in closing costs. Usually, you don't want to go over 3% of the sales price. So if it's $300,000, you don't want to put more than $9,000. Okay. But if you do put closing costs, sometimes it looks a little funny because you're paying cash. They don't understand that, but it's okay. Don't worry about it. That's a whole nother subject on mentalities that we'll go into later in another class. Prorations means that, hey, the title company says the seller stayed in the house 6 months and now you're getting it on 6 months, so you're going to pay half. He's going to pay half the taxes and insurance. No, it's not rocket science. Prorated for everything. I mean, it's just straight math. Casualty loss, if any property is damaged, destroyed, then you don't have to buy the property. If it's it got burned down, you don't have to buy the house. A car ran into it, you don't have to buy the house. Default, if buyer fails to comply with contract, that means that he defaults, you lose your earnest money if you don't have any loopholes, and we talk about the loopholes. Same thing goes with the seller. If the seller defaults, and you can take them to court, and then most likely if you have this contract and it's If it's done right, it's solid, then you can get a substantial amount. Yeah, it's a no-brainer. You disclosed everything. You closed all loopholes for the seller, and you did your job. Then you're owed a payment. Easy as that. Mediation means that exactly that. Somebody who will sit in the between you guys, a mediator, so you don't have to go to court and just kind of be fair. It's like, hey guys, we have a problem. Let's hire a mediator. Charges $100 an hour. Let's split it and let's see if we can come to some kind of mediation before we go to court. And you guys both agree to do that. Attorney fees, whoever's at fault. So if buyer's at fault, if the buyer will pay the seller attorney fees, and vice versa. If the seller's at fault, then the seller will pay the buyer's attorney fees. Just like lost damages and stuff. And escrow, which is the same thing as title, is basically it's a party that doesn't care about you, doesn't care about the seller, doesn't care about the inspector, the realtor, anybody. All they care about is that the title is free and clear, and they're going to be holding money, your earnest money, and making sure that all the I's are dotted and the T's are crossed, and transfer that money once it's time to fund that transaction, and then pass over the keys to you, and that's it. And then, of course, there's a little thing here, demand upon termination of the contract, you both have to sign off on the termination of contract. That's another form that we'll talk about in an advanced class, terminating, getting your earnest money back. Okay, now moving over to escrow. So the escrow is the title company, and it's basically a company that doesn't care about you, doesn't care about the seller, doesn't care the buyer, doesn't care about the realtor, doesn't care about the inspector, doesn't care about appraisals. All they care about is that title and being fair to each party. They're just like, hey, I'm in the middle, buddy. All I'm going to do is make sure when this buyer gets the property, it's free of all liens, encumbrances, taxes, liens, every single thing. And if it's not free, I'm going to disclose it. I'm going to let them know, hey, it's not. And it's in that title policy saying, hey, this is what it is. They're going to sit there and just tell you, just be right in the middle and be straightforward with you. One tip, it's in advanced courses about the title company. They're not your friend. They're not your friend. So I've seen a lot of deals fall through at the very end because people are too honest. Oh, I was in the house doing repairs. Wait a minute. You were in the house doing repairs before? Oh, we're going to stop closing. Don't talk at title company. They're not your friend. Get on your phone. Where do I sign? Sign, get out. Trust me on this. Just trust me. They're not your friend. Write that down. Okay, so if you need to terminate this transaction, then the buyer and the seller both have to sign off. You're going to be using another form called termination of contract. That's one of the templates we have, and basically each party needs to sign off on, just to be fair. And if not, they just keep the earnest money there at the title company. It will stay there until both parties come to an agreement, or they have to go to court or a court order. Representations, survive all covenants. Okay, that's all. Federal taxes, if the old federal taxes, of course, are going to pay off all taxes. Notices, you need to put where to put a notice from, and make sure that you put in there, it's in our template, that you will accept email notices. But you also want to have a place that you get mail at. In case they send you a certified mail, you want to make sure you get it, just in case something comes up. You want to cover your ass. And the same thing goes for the seller and the buyer. Have him put, where do you want this notice in at? Because if you go to court, or you happen to need to do something legal, then you want to say, I sent the notice. Here's a return receipt that was sent. He signed for it. And this is where he said to send the notice. Thank you, Judge. And boom. You see where I'm going. CYA, cover your ass. Okay, agreement of parties, what forms are contained? In the template, it just says what forms. There's no fancy verbiage here. What forms are a part of this contract, and you check which ones are a part in here, okay? We're talking about financing. We talked about if there's a homeowner association, if there's a any kind of seller's temporary lease, a short sale addendum, anything like that. And of course, I like to put on here that says consultant attorney. What does that CYA cover your ass? Because you don't want to have any problems. So who is my attorney? If you have one, if the seller has an attorney, but if he doesn't have one, just knock it out. I mean, at least you had a contract that had it and it had all the rights for him to get one. You gave notice. CYA cover your ass in case you have to get in some kind of legal proceeding. Executed, that means when did all parties sign off? You only want to fill this out when everybody signs off. Executed this day, and usually the title company will sign off on it, but if it doesn't matter, but it does need to be filled out for the loan. Okay? A buyer, you will be putting your LOC. Hopefully you got that done from the previous class, and the seller signs off, and he'll be initialing each page. Oh, and this is where I say here, this form has been approved by the state intended for real estate license holders. This is what I mean. You have to have a license to use this form. So I say create your own form, hire an attorney to use to create you a form, or use our template, and always do your due diligence. Okay? We don't take any, if you have something happens, you don't want to be responsible. And this is if you are a realtor, then you can get a commission. Of course, you want to go ahead and say get your commission because that's an extra 3%. Try to get it. If you don't have a real estate license in that state, then talk with the realtor. Say, hey, I'm going to be getting a real estate commission. Here goes the agreement between us. You're going to give me 2 points back. You didn't do anything, but you are the realtor on this. You have a friend, best friend, and in return, maybe I can't say this legally, but he can give you certain favors, certain access to certain data. If you get my point, like I can't say I'm a real estate broker. I can't tell you things that are against the rules. You do your own diligence. These are just things that I'm telling you. And okay, so and this here goes 3% is where they're going to pay you. The seller will pay you, and you just you have another contract written between the two of you. Earnest money receipt of. Oh wait, here we go. We skipped over option fee. And in fact, we didn't talk about option fee as much as I want. Let's pull that back up. Right here. We skipped over here. Page 8 of 10. I don't know how we skipped this, but this is super, super important. I think I saved the best for last. So termination option in the template is just option fee. And what happens is says for 10 days, or for X amount of days, as many days as we can get. Sometimes I've seen 20 days for free. Seller just doesn't pay attention. He's just signing stuff off. The more, the better. The more protection, the more loophole for you. Yeah, but if worst case scenario, 10 days for $100 is the 99% rule. But once you start getting into more expensive homes, then it says $500,000. Then that's going to go to $500 for 10 days, sometimes $250, but you want to get it as low as possible because you're going to lose that option fee. But if you close on it, it gets credited back to you, as you can see here, the option fee. Okay, so it's super important. You have to have that option fee in there. We also have, so let's talk about the loopholes. Now that I got you here, let's talk about the loopholes. So we have a termination option fee 1. Then we have another one. We have another loophole. If we can pull it up here, that was under seller survey. Let's take a look. Let's pull it up. Okay. Survey must be registered within 5 days that the seller shall furnish to buyer entitled existing survey. Seller fails to furnish existing survey, buyer shall obtain a new survey at seller's expense. The seller shall pay no later than 3 days prior to closing date. Now, okay. Let's move. Okay, so the second one will be the objections for the title policy. So buyer must object the earlier of the closing date or 15 days after the buyer receives the title commitment, exception documents, and the survey. Buyer's failure to object within the time frame allowed a waiver of buyer's right to object, and Schedule C would not be waived, blah, blah, blah. Seller is not obligated to expense. But the main thing I want to say here is buyer may object to any matter revealed in the revised commitment or survey or new exception within the same time frame. And basically, this is what it means. Let's go through a scenario here. You've got a property under contract. You send it over. Everybody signs off. Goes to title. Title policy gets sent to you a few days later. You look at Schedule B, A, B, and C. You find some kind of encumbrance on Schedule C, and you're like, "Whoa, what is this encumbrance?" So you can terminate, and let's say it's day 14. I object. I didn't know about this encumbrance. I didn't know whatever's on Schedule C, and I want to go ahead and object and use my clause. So not only now do we have our option period, but we have our objection and title loophole. Okay? So now we got the option fee to back out, get our earnest money. Number 2, we use a title policy commitment objection. That's right here. You object if they can't clear that. I mean, we're just saying if it's day 14, it's past your option. Of course, do your own due diligence. But I'm just telling you what we have used in the past. And now we're going to be saying one more. Let's see here. So another one, if you did not receive the title commitment 20 days after the title company receives a copy of this contract, the seller shall furnish to a buyer a commitment for the title insurance and a buyer's. So basically, if you don't receive it within 20 days, you can object and get your money back, your earnest money back. Okay, so now we have 3 different ways to get out of a contract. Well, number 1, the option period. You can back out for any reason, write as many days as you can, as cheap as possible. Just $0 if the seller doesn't catch it. Put as low as money, because that's the money you'll lose if you need to back out. Then of course you have the seller's disclosure loophole. This is he didn't disclose something to you or never gave you the disclosure, you back out. Then the third is the title commitment. These are your Hail Marys to get out. This is like, let's say for instance it's day 29 and you need to close and you can't do it, and you need to get your earnest money back. Okay, guess what? Title commitment was never given to me on time, or I object on these different things that you find in Schedule B and C, whatever the case may be. These 3 things, use them, write them down, use our template, I beg you, because these things are already spelled out to you in the little addendums. So I hope you enjoyed it. This is our class on wholesale real estate training, and I will talk to you guys soon. Give it a big thumbs up if you learned a few things. Share it with your friends, and I'll talk to you guys soon. Go wholesale those properties. There's plenty of money out there. Be a little creative, and you can get it done. Talk to you soon. Bye-bye.
Thanks so much for tuning in and watching my video. Please give it a good thumbs up if you liked it or if you learned something. Hit that subscribe and notification bell. That will keep you learning. I'm throwing videos out there every single day about learning new techniques, negotiation, money-making skills that I've learned over the last 15 years, and I'm continuously giving you new tips. So follow us on YouTube, Facebook, and Instagram. Whatever avenue you're on, we are there. God bless, and I'll see you on the next video. Bye-bye.